It's wrong, it's counterproductive, and it's in violation of the principles of natural justice. People are entitled to say what Shankar did. Everybody knows that there is considerable corruption in the judiciary. Saying something like this, in my view, does not amount to contempt. That a judge who has some interest in the matter is dealing with it when he ought not to have dealt with it, he ought to have recused. Order doesn't read well and doesn't augur well for the judiciary.
Hello and welcome to News Minute. The Madras High Court on Thursday, September 15th, held YouTuber and whistleblower Savukku Shankar guilty of contempt of court for his remarks against the higher judiciary. The court has also sentenced Savukku Shankar to 6 month imprisonment, simple imprisonment, and he has been lodged in Kadalur prison. Justice G R Swaminathan of the Madurai bench of the Madras High Court had initiated suo motu contempt proceedings against the YouTuber for his remarks, saying that the entire higher judiciary is riddled with corruption. Joining me today is senior advocate Prashant Bhushan. He is also a civil rights lawyer. Thank you so much for speaking to us, sir. You had mentioned in your comment that this judgment is unfair. Why do you say so, sir?
Yes, for two reasons. Firstly, you see, some of the remarks for which contempt notices were issued suo motu by this Judge Swaminathan were also directed against Justice Swaminathan himself. And therefore, especially when the judge was told to recuse himself because he had a conflict of interest, he ought to have recused himself. Instead, he said, because the Chief Justice has assigned this bench, therefore I must hear this. There is no such rule that if the Chief Justice has assigned a bench, he must hear it. If there is a conflict of interest, he must recuse. And here there was a conflict of interest, so he ought not to have heard it. Secondly, you see, it is totally wrong in my view to hold somebody guilty of contempt for just saying that the judiciary is riddled with corruption. Everybody knows that there is considerable corruption in the judiciary, and therefore people are entitled to say what Shankar did. Now, the view that many judges have that power of contempt should be used in order to prevent people from exposing corruption in the judiciary. This is so that it does not destroy public confidence in the judiciary. This is a totally wrong view, because public confidence in the judiciary is not dependent upon whether people are punished for saying that there is corruption in the judiciary or not. It depends upon how the actions of the judiciary are seen by the people. In fact, such attempts to stifle criticism of the judiciary by the threat or the power of contempt is a sure way of bringing the judiciary into further disrepute and destroying further confidence, public confidence in the judiciary. Therefore, that is why this branch of contempt, that is bringing the judiciary into disrepute, this part of contempt has been done away with in most civilized countries, including UK, from where we have borrowed it.
Yeah.
See, and we have challenged this part of the contempt law in the Karnataka High Court. Our challenge is pending in the Karnataka High Court. Arun Shori, then Mr. N. Ram, and I, along with the former editor of Outlook, Mr. Prashant, we have together challenged this part of the contempt law. So that is why I say that the judgment in this case is not merely wrong because it has been given in violation of the principles of natural justice, that a judge who has some interest in the matter is dealing with it when he ought not to have dealt with it, he ought to have recused. Secondly, it's not correct to punish somebody for merely saying that there is considerable corruption in the judiciary. Whether he words it by saying that it is riddled with corruption, or whether he just said there is considerable corruption at all levels of the judiciary, comes to the same thing. So, in my view, it's wrong, it's counterproductive, and it's in violation of the principles of natural justice.
But what is the procedure, sir? If the court is taking a suo motu contempt case, what is the procedure? Like you said, if the judge has some interest in this case, he should not hear the matter. But in this case, we have seen, exactly the opposite happening. Because the earlier contempt notice was very clear, because it was directly on the remarks that were made by Shankar against the judge who
Yes.
initiated the suo motu contempt.
Yes, yes. So there is a specific provision in the Contempt of Courts Act that for contempt committed in the face of the court, the judge in whose face the contempt has been committed should recuse himself immediately if some objection is raised. And the principles of recusal are well settled, that if you have some interest in the matter, then you ought to recuse yourself from hearing that case. In fact, in that there's a case which went to the House of Lords where uh, one of the 11 judges had some sort of connection, some remote connection with the petitioner organization, and yet the House of Lords held that that judge ought not to have heard that matter, and therefore that order was set aside. So therefore, it was very, very important for this judge, Justice Swaminathan, to have recused himself and not heard this case at all, where there was clearly a conflict of interest. And secondly, even otherwise, you see, because I read from your report about it that this was pointed out to him and an objection was made that he should not be hearing it. Yet he proceeded to hear it by saying that the Chief Justice has assigned this bench, therefore I must hear it. That is certainly no good reason for him to continue to hear this matter.
And also, sir, the manner in which the trial was conducted, because some say that the respondent was not given enough time to put forth his argument because it was back-to-back hearings and the time was very short. What do you have to say about that? Like,
So
how
I'm
does these contempt proceedings happen? Because you yourself have faced a contempt of court case. So, how does this entire process take place, sir?
no, I am not aware of how much time was given to Savukku Shankar for responding to the contempt notice. Uh, but certainly adequate time must be given in, especially in contempt cases. There is certainly no such tearing hurry, and the court should give adequate time to the respondent to respond to the allegations. I don't know exactly how much time was given in this case or not, but certainly the order doesn't augur well or doesn't read well and doesn't augur well for the judiciary.
So the right to criticize judiciary in public forum, that's something that's being debated now, or even it was being debated before. But after this case, there is a lot of debate that is going on. Where do we stand now, sir? Can people criticize the judiciary in public forum? Are they allowed to do so, or will they have to face contempt?
No, people are allowed to criticize or discuss the judiciary in a public forum. There is no dispute about that. Uh, but you are not allowed to accuse a particular judge of being corrupt uh, because unless you have evidence of that and you plead truth as your defense. So if you accuse a particular judge of being corrupt, you must have the evidence to show that what you are saying is true, because truth is a defense in a contempt case. So otherwise, suppose you say that there is considerable corruption or the judiciary is riddled with corruption. In my view, you only have to say that that is my perception. And you can, if you are asked to prove the bona fide reason why you believe that perception, you'll have to give some evidence. as to why you believe that there is considerable corruption or the judiciary is riddled with corruption. But uh, in my view, making such remarks, especially when it is well known and well understood that there is indeed considerable corruption in the judiciary. It's been acknowledged by a very large number of former Chief Justices of the Supreme Court, a very large number of former judges of the Supreme Court, etc., that there is considerable corruption in the judiciary. Saying something like this, in my view, does not amount to contempt.
And also in the year 2021, Member of Parliament D. Ravikumar had moved a private member bill to curtail the contempt powers of the High Courts and Supreme Courts. It's time that something like this should be done. What do you think about this?
Yes, that is why we have challenged the provision. See, contempt is of three kinds. One is civil contempt, disobeying an order of the court. There is no problem with that. Criminal contempt is also of two kinds: obstructing court proceedings, interfering with the administration of justice. Now, anybody who obstructs court proceedings or threatens some judge or threatens even a litigant, look, if you go ahead with this case, I'll break your leg, etc. That's obstructing court proceedings, obstructing the course of justice. That is criminal contempt. There is no problem with that either. The problem is with the second part of criminal contempt, which is scandalizing the court or lowering the authority of the court. This is the problematic part, which has been used by many courts to punish people who talk about problems in the judiciary. Now that is problematic, and that is why Mr. Arun Shori, Mr. N. Ram, Mr. Prashad, and I have challenged that, and that challenge is pending before the Karnataka High Court. That's the problematic part. So we have to get rid of that. UK, England, from where we have borrowed this part of contempt, has already got rid of this. In America, there is no such thing as contempt by scandalizing the court or lowering the authority of the court, etc. In most civilized countries, this branch of contempt law doesn't exist. It exists only in India, and it's high time that we did away with it.
Thank you so much, Prashant Bhushan, for sharing your thoughts. It was a pleasure talking to you.